X. And he has said some battles are fought to be lost, for history must record the uncomfortable facts for generations to know. The right and wrong of institutional actions will be debated for years to come. History alone is the final arbiter of the moral compass of historic decisions. History alone is the final arbiter of the moral compass. So this is what Kapil Sibal has posted. Ananya Bhatnagar joins us live. Some battles are fought to be lost. Does that mean that they have already thrown in the towel? They know what the decision is going to be, Ananya. And history must record uncomfortable facts. The facts about what has happened with 370, how it came into play, how the Home Minister of the country was kept in the dark, how the Prime Minister of the country sacrificed and compromised Bharat's interests. These are all uncomfortable facts too.
Well, definitely, Anand, all of these are uncomfortable facts, and there seems to be a preempt of the judgment today by senior advocate Kapil Sibal, who had led these submissions for, in fact, the petitioners. In fact, he was the first one to begin these arguments on day one, very, very categorically saying that with the abrogation of Articles 370, the state has lost everything. The people have lost their mandate, and in fact, the right to be consulted with as well has been lost by the people of the Jammu and Kashmir. However, the central government coming in with a strong defense, saying that it is in a very, it is going to restore that statehood to the state of Jammu and Kashmir. The elections would be held very, very soon, though a particular timeline was not given, but definitely a framework of the electoral system in the state of Jammu and Kashmir, that would be a state of Jammu and Kashmir, had been given by the Solicitor General of India on the day 14th of that particular hearing, very, very clearly stating that, there would be a three-tier Panchayati Raj system that would be introduced first. There would be elections to the Panchayati Raj.
See, then, it's all about what is going to happen hereafter, Ananya. See, so in terms of the 14-15 day hearing, like you said on day 14, they said what's going to happen now. It's not about what has already happened. So was that indicative of which way this entire decision is going to swing? It is about bringing together Bharat as one. Akhand Bharat, no more partitioning of Bharat. Akhand Bharat has different interpretations for different people. We are talking it from, saying it from one point where it says that this is one Bharat since 1947. It should not have different interpretations and different rules across its various states and union territories. Now, what are the arguments made by the petitioners in the Supreme Court before we bring back Rahul and also go across to our other reporters? The first argument that Article 370 became permanent after dissolution of the Jammu and Kashmir Constituent Assembly in 1957. That's the first argument. Second argument is that the powers of Legislative Assembly of state can't be taken over by the Parliament or by the centre. The third argument is Constituent Assembly can't be substituted by the Legislative Assembly for Jammu and Kashmir. The fourth argument is that the state is part of the basic structure doctrine. Jammu and Kashmir can't be an exception. Argument 5, violation of the constitutional promise as no merger agreement was signed with Jammu and Kashmir. So these are the 5 arguments that have been made. In it itself, there are a bunch of contradictions, Rahul, because on the one hand, in argument number 4, they say that Jammu and Kashmir cannot be an exception. But 370 itself was on the ground that Jammu and Kashmir will be an exception. So, chit bhi meri, pat bhi mera, heads I win, tails you lose kind of argument that have been made by the petitioners. But there were countermeasures that were taken. In the build-up to the abrogation itself, the Constituent Assembly was deemed to be Legislative Assembly as per the presidential notice.
Absolutely, you're absolutely right. Today, of course, viewers, let's just home in on the exact issue that is going to come up for consideration, which is, as Anand has been telling us, whether the Constituent Assembly's writ, which was dissolved in 1957 of Kashmir, prevails, or is it union government represented by the Lieutenant Governor who passed that order in consultation with the President. Now, I want to draw your attention to what Chief Justice of India, D.Y. Chandrachud, had said on September 4th. On this particular point, he said, petitioners were placing Article 370 on a pedestal loftier than the basic structure doctrine of the Constitution and even beyond the reach of the amending powers of Parliament. Can you believe it? This was the concession that was made. This was the concession that was made. And let me tell you, this argument about, oh, the Constituent Assembly, that cannot be considered a legislative assembly, etc., is slightly fallacious. We had spoken to Harish Salve at one point, even in the context of the research for my book, and he had said that, look, the Constituent Assembly dissolved. in 1957, and it did not proclaim whether the Article 370 should continue or whether it should be withdrawn.
Yeah.
And then quite obviously from there on, just like at the center, where the parliament of the day, the central legislature of the day took over from the Constituent Assembly, the Legislative Assembly of Kashmir took over from the Constituent Assembly of its state.
Yeah.
And because there was president's rule, there was central rule, Anand, the president could take a basic call on this in consultation with the lieutenant governor, who was the executive authority in the state, on August 19th.
Now, August 5th, 2019. So,
Yes,
3rd of
2019.
August, 4th of August,
Yes.
the entire decisions were taken. The decision was then ratified by the parliament, both in both the houses and with 370 votes. That's what also happened. That 370 went with nearly 370 votes in the house. But